Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
We're not doing subjective questions, sir. I have a full docket today. We're here to get to the point. We're not doing
Yeah,
subjective.
my point is that I do not believe I was doing 91 or 92 miles an hour.
What's your name, sir?
The principal name is Joseph Montez Logan. I'm an agent on behalf of the principal.
I'm sorry, say it one more time.
I got a doable power of attorney filed in Wayne County Register of Deeds. The principal name is Joseph Montez Logan. I'm an agent on behalf of the principal.
Okay, you're Joseph Montez Logan
Yes,
or Logan?
Yeah, that's my principal. Yes, ma'am.
That's your name. Sir, I'm Magistrate Chartea. You're here on a criminal matter. 250-453-2601. You have an attorney. Go ahead, counsel. Counsel Reagan, you wait for a reading. Stand mute.
Judge, he's representing himself. He's the principal or the agent of the principal attorney of himself. He's representing himself.
Okay. So, Mr. Logan, you want to waive the form of reading, or do you want me to read the charges?
I would like to see the discovery first and the nature of the cause.
Okay, the discovery, that comes after, sir. Okay, this is only an arraignment. So my question is do you want me to read the charges to you or not?
Yes, ma'am. I'd like to hear the reading.
Okay. So, sir, people of the state of Michigan versus Joseph Montez Logan, allegedly on May 15, 2025, in the area of 18637 Albion Street, City of Detroit, did commit count 1, domestic violence, did make an assault or assault and battery upon a Tanisha Logan, a resident or former resident of his or her household, and or an individual with whom he has a child in common, and or his spouse, contrary to the MCL 750.812. Okay, maximum penalty is up to 93 days jail and or $500 fine. Do you understand that, sir?
No, ma'am. I do not understand that.
You do not?
At the moment,
what is it that you do not understand?
Well, because MCL 12.280 gives you the personal liability of my agent capacity, and that gives you understanding of 1 and 2, saying that I have the same rights as a self-appointed a state appointee, the same rights as a state appointee, and I have no interest in this matter.
Here is the reality. Even if some government-appointed official assaulted his girlfriend, he would still end up standing exactly where you are today.
Okay. Well, sir, you are the individual. I'm going to enter a plea of not guilty. It alleges that you did make an assault and battery on a Tanisha Logan. Okay. Again, the penalty is up to 93 days jail and or $500 fine. I'm going to enter a plea of not guilty. Let me give you your court date, sir, which is going to be May 28, 2025. Free trial. It's an in-person hearing. Let me make sure. 8:30 in person here at 36th District Court in front of Judge Austin Garrett. Do you understand that, sir?
No, ma'am. No, I do not.
No, I don't think that. I think you do understand, sir, because by your talking, okay, you do understand English. Whether or not you disagree with it, sir, that's another matter, Mr. Logan. But everything is placed on the record because everything is being recorded, sir. But I do believe you understand English. I'm giving you that court date. I'm also letting you know, sir, in terms of whether or not you wish to go forward, however it is, that's going to go in front of Judge Austin Garrett. Do you understand that?
No, ma'am. I do not understand any of the matter, any of the charges, none of what you're saying, because I'm actually the agent on behalf of the principal.
Okay.
Well, in this case, and you try to build a case on me personally, and I'm not liable. I don't have an interest in this matter.
Okay. Thank you, Mr. Logan, but you place that on the record. No. I've heard that. Sir, you still have that court date. I gave it to you. Okay. If you do not show up, a warrant will go out for your arrest. As to whether or not, like I said, when you want to argue as to motions or not, that's going to be between you and Judge Garrett. Okay. Let me give you some bond conditions, sir. That means you need to abide. You're not to have contact with a Tanisha Logan. That means no person-to-person contact. No contact with third parties, no phone calls, no emails, no text messaging. You're not to possess any firearms or any other dangerous weapons. And you're not to go back to the No, that's your residence. So I'm not putting that on. Just no contact and no firearms. You understand that?
happens with the minor children involved?
What amazes me is how their concern and devotion toward their children suddenly appears whenever their freedoms face restrictions. Somehow, I doubt those kids crossed his mind while he was treating their mother like a punching bag.
As to the minor children, sir, okay, that's up to family court. So I'm not dealing with the minor children.
So there's no stipulations?
Those two conditions, okay? I don't see anything to indicate that these children are subject of this case. So do you understand what I've just said, everything so far?
Ma'am, I do not understand, but I will take your ruling on behalf of the principal. I can only do what I can.
Okay, no problem. Okay, this allegedly happened at your residence, sir. I also see in this particular matter, there was no injuries. The complaint declined medical attention. Let me see what else.
I got a question, ma'am. Is she moving forward with the case?
Hold on.
Okay.
There was a 2016 domestic violence misdemeanor. I don't have anything else. What's your question, sir?
Is Tanisha Logan moving forward with the case?
Is she a what?
She's pressing charges, Tanisha Logan.
Okay. So you understand, Mr. Logan, okay? It is not up to the complainant to press charges. Charges come from the county, the prosecutor's office.
Oh, okay. Well, I'm just of the understanding that the state of Michigan is a legal fiction. It's not a living person.
Okay. It's the state of Michigan. That's why I read the state of Michigan, or the people of the state of Michigan versus you, sir. So
Okay.
It is up to the prosecutor's office that files the charges. They have filed the charges. Whatever happens after that, that's going to occur in front of Judge Austin Garrett, his courtroom. So I see that you have local ties. Anything else you want to add, sir?
No, not at the moment. No,
Okay, well, this is going to be it, sir. In this case, bond is going to be $25,000 personal bond. Nobody has to pay any money for you to get out of jail. I will caution you, sir, that you have no contact with the complainant. Even if the complainant wants to talk to you, you cannot, because you're under court order. Now, you can take all those issues up with Judge Austin Garrett on your court date of May 28th. Do you understand that, sir?
I was of the understanding that this was a misdemeanor charge and not a criminal charge. So I don't understand how.
No, it is a criminal charge. Anytime when you can go to jail, you can be incarcerated, it is a criminal charge.
Yes, that's crazy. Okay, well, I'll just fight it in court.
So $25,000 personal bond. Good luck, sir. You can step aside.
As you may remember, another hearing had been placed on the calendar several days later before Judge Garrett. However, he ended up appearing before Courtroom favorite Judge Perkins.
Okay. Get you started on logins. Joseph Loggins. You there, sir?
Yes, I'm here, sir.
Good morning to you.
Good morning.
It's just log in. It's not logins, is it?
Yeah, no S.
City of Detroit versus Joseph Logan. Case number SP 1322877, counts 1 and counts 2. SP 1688005, counts 1, 2, and 3. SP 1688081, counts 1, 2, and 3. Appearance for the record, please.
Kathy Murphy, P51422 for defendant Loggins, who appears via Zoom, as do I, sir. Please state your name for the record, or ma'am.
Joseph. Sir.
Sure.
All right. I'm going to put you in a breakout room, Mr. Logan, with Attorney Murphy. She's going to get you an updated offer. Keep in mind, if you don't like the offer, you have an absolute right to a trial. Let us know what you want to do when you come out. Join the room, please. See anything here that's affecting him from getting a valid license if he doesn't already have one? It's past the matter. Let's go back on the record with Mr. Joseph Logan. Mr. Logan, I've given you an opportunity to speak to counsel. Counsel, your client wants a appointed attorney.
Yes, Judge, he would like to proceed to trial, and I'm asking the court to have an attorney appointed to assist him.
Here on this here this is sort of like, I mean, we can appoint one, but this is sort of like everyday stuff that we deal with every single day. It's only really documents. Go ahead.
So, pardon me for interrupting, Judge. Mr. Loggins has some sovereign citizen type claims to make in connection with these tickets.
Take your head off. So if he got the sovereign citizens claims, and he doesn't want a lawyer anyway. Take your hat off, Mr. Logan.
He did.
Go ahead.
He did say that he would like standby counsel. Mr. Loggins has some unique claims to make, Judge, that I cannot adequately represent for him at this moment.
Honestly, do not blame yourself. Unless your law degree came straight from Crayola's experimental crayon sampling division, there is no chance you will understand his argument.
But they sounded like sovereign citizen claims to me.
And I'm sure probably no lawyer in the country can make that. I mean, he may be able to find himself a lawyer in the country that may try to make that claim. But Mr. Logan, what do you want to do? I'm going to set a jury trial for this sovereign citizen stuff. Is that what you're?
It's not sovereign citizen stuff, sir. It was due to the vehicle being registered to a living trust at the time of the stop. So I was just informing the attorney that the claim is basically due to a trust being stopped. My vehicle was registered to a living trust.
Okay, thanks.
So the trust being the owner of the vehicle. So I just wanted to move forward as the trustee of the trust, if you will allow it.
Man, that's some double talk there, isn't it?
Judge, could I maybe jump into, I think I get what Mr. Logan saying. If I could go into a breakout room with him for a second, I can talk to him. I'm still waiting for my client anyway, so I got some time.
All right, here we go. I told you there's a lawyer in the country that might want to represent you.
Thank you, Attorney Dupree.
All right, I'll put you in a breakout room. All right, let's pass the matter. All right. Let's go on let me take care of Mr. Dupree's client. Let's go back on the record with Logan. Logan, you want a trial date, right?
Yes, trial by jury.
Yeah, I think this would be best in trial by jury. Let the jury of his peers determine if they feel. Can I get a jury trial date, please? Are you going to be sitting with him on this, Mr. Dupree?
Judge, he is. He does want to represent himself, but he is asking for standby counsel. I'd be happy to serve in that role. I am on the Third Circuit standby counsel list, if the court would be willing to assign me.
I'll assign.
Thank you, Judge.
They do jury trial on certain days.
They have a list.
Third Circuit does, Judge. At 36, it's all the same list. There's just one list.
No, you're saying, I'm saying the list for the jury trials. Let's see if I can find the dates on the list of jury trials.
Judge,
July 8th. What about July 8th?
I was actually going to say, Judge, I have June the 24th. I'm currently booked for a jury trial in front of you. If the court doesn't mind double booking it, and I will, of course, note that Third Circuit frequently double books trials, I wouldn't mind double booking that either, and we can see which one, if either ends out going.
Jury trial, June 24th. Okay.
Very good, Judge.
And then what's the final pretrial on that other case?
I knew you were going to ask that question, but still couldn't find the information fast enough. Give me 1 second, Judge. Judge, the final pretrial is the June the 23rd. You said it the day before.
June 23rd. June 23rd. Your next court date is June 23rd. Let Miss Snyder know that we want all the parties to appear on June 23rd. And not necessarily in person, but we want to make sure that they're gonna bring all the parties, so we don't order a jury if not. And that's gonna be the same for your other June 23rd case as well.
I will let her know on both cases. And with Mr. Logan's permission, I'm also going to reach out to Ms. Snyder to request discovery in this matter.
Mr. Logan, do you give him permission to get the discovery for this matter?
Yes.
Although I completely reject everything connected to the sovereign citizen movement, I will give him credit for finally ditching the script, recognizing the court's jurisdiction.
Then.
Right. Final pretrial, June 23rd, 2025. You know that the trial date is going to be in person. It's not going to be on Zoom. But the day before that, the June 23rd date can be on Zoom, 8:30. If you have any motions, I don't know if you're going to have any motions or not.
Yes, I'm gonna have some motion, sir.
Okay, so a motion date, you're going to have to get those in pretty quick.
That's what I wanted to see if you can like extend the time so we can get discovery and look at it and analyze it.
I don't know how much analyzing you're going to need on driving license suspended, no insurance, and an unregistered untitled. I don't know what's really, it's not that in depth. I'm going to give you. You have Mr. Dupree. He's probably going to reach out to them today on that. I'm going to give you until June the 13th on a response on the motion. Motions due June 13th, and the responses will be due June the 20th, okay? If there's nothing further, Mr. Logan, I wish you the best of luck. Have a very good rest of your day, okay?
Okay, sir, can you repeat that again? You say the motions are due June 13th and the responses are due
June 13th, and the response is going to be due June 20th, and I'll make a decision on the motions on the final pretrial date.
Okay, thank you.
All right, best of luck to you, sir. Have a very good rest of your day.
You too. Bye.
For now, we are traveling to Kitts County, where a male Karen has arrived in court to dispute a speeding citation he received after driving behind a police officer.
Mr. Allen, we're going to wait until Trooper Alcock is connected to audio. It looks like he is. Trooper Alcock, if you could please turn on video footage and unmute yourself. Do you have video footage, sir?
Yes, Your Honor.
Awesome. Thank you. All right, here. So we are here in 5A01111624. We have Adam Allen here. So, sir, first of all, before we begin, I do have to just make a statement that Cowlitz County does offer a program. It's called the deferral program, where we defer making a finding and reporting anything to the Department of Licensing for 12 months if two conditions are met. First condition is that you don't have any new traffic infractions during the duration of this 12-month period. And the second one is that you pay an administrative fee. And your situation would be $150. It's not applicable if you have a CDL or you did this within the last 7 years, which doesn't apply to you. It looks like you could actually enter this program if you wanted to. Before we begin, I should ask, are you interested in this program at all?
No, simply because I do not believe that I was doing 92 miles an hour, and I do not believe Trooper Alcock has any proof that I was doing 90 miles an hour.
All right, great. So I'll go ahead and decline that program, sir. So I do see that you submitted a subpoena for Trooper Alcock to be present today. Service, let's see. I don't know what this documentation is, but obviously the trooper is here, so I am going to let you go ahead and call your witness as you subpoenaed him. So go ahead and begin.
Yes, sir. So you were traveling southbound in the left lane of I-5 when you came in front of me and then subsequently pulled me over and claimed that I was doing At the scene, I believe you said that you clocked me, quote unquote, at 91 miles an hour. Is that correct?
It was 92 miles an hour, but generally
At the-
speaking, as he said.
Okay, so you wrote the ticket for 92, but at the scene, you claimed you clocked me at 91. So what device did you use to clock me?
A B3 radar.
And do you have proof of that?
Yeah, it's mounted in my car. I have a front
Okay,
antenna.
do you have the actual proof of clocking my vehicle going 92 miles an hour to submit to the court? I did request that, a subpoena of your device as well, and any devices that were used to document my speed. That subpoena was not issued to me.
So whenever you are utilizing a B3 radar, the readings are transitory. It's not like you lock a specific speed as you're tracking the moving target. The speed moves up and it moves down.
So you have no
There's not
proof?
like a kick.
Please do not interrupt. If you are asking questions, you let Trooper Alcock answer.
My apologies, Your Honor.
So the readings go up and they go down. There's not a way they like lock in and you can save the reading. So when you're tracking a vehicle, let's say, as it's moving from 90 to 91 to 92 miles an hour, moves up and it moves down. It doesn't like lock in, so you can maintain that reading to show to a court.
Okay, so there is no documentable proof of my speed.
Just that I've sworn on a sworn statement that you were traveling 92 miles an hour as I
Okay,
observed
but
it.
you did say at the scene that you clocked me at 91 miles an hour. So we're supposed to take your sworn statement at either on the scene at 91 miles an hour, or that you then, after reviewing the ticket, which had another error where you claimed the truck was black even though it was blue. So your ticket is riddled with errors. And we're just expected to take your word that—
Mr. Allen, these are questions. You're not supposed to be making any argumentative statements or any subjective statements. You only ask questions.
Okay, so my question is, do you have any proof to show my speed at 92 miles an hour?
Have you ignored everything said until now? The officer already explained that his evidence is the sworn, signed declaration written on the traffic citation. He did not merely measure your speed using radar.
The proof is that I observed it, and I wrote on a sworn statement that I observed it as such.
And do you recall telling me at the scene that you clocked me at 91 miles an hour?
I don't recall specifically whether I told you 91 or 92.
Do you recall me ever passing your vehicle?
Eventually, when I moved out of the way so that you could pass me, because when I observed the speed, you were well behind me.
Correct. And what lane were you in traveling when you observed me from behind you, apparently doing 92 or 91 miles an hour?
Yes, like you said, I was in the left lane and you were in the center lane. You had moved from the left lane to the center lane at that high rate of speed. When I saw you speeding, activated my rear radar and obtained the speed reading.
Okay, and so I don't know how radars work, but I do know that Washington state law does require a testing of proof of the device every 2 years. Can you furnish that proof to the court that your devices have been tested and collaborated with in the last 2 years?
I don't have the exact documentation on hand, but I do on my radar. It does say it's within certification. I tested it before my shift that morning to certify it was working correctly, and I certified it after the end of my shift to make sure it was working correctly as well.
So to verify, you do not have any proof that your devices have been calibrated per the law.
Mr. Allen, to just save you some time, pursuant to RLJ 6.6, if you go to the Washington State Patrol certification of any speed measuring device, there is a 6.6 ruling that's out there. You put in the number of the radar, which in this situation is R2734. You put that into the State Patrol website. Out comes in the documentation that shows that it has been certified, shown, accurate, and reliable. I don't know if you did that on your end, but it does exist. Troopers do not carry that paperwork with them. It is public knowledge on a website. So he would not have that documentation with him.
Okay, and I did ask in my original subpoena for the officer to also provide the subpoena to get the devices, to subpoena the devices themselves that would have provided that. So I don't understand, because
What did you subpoena? Here, let me look up your subpoena request. So your subpoena request here.
In my communication to the court.
Yes, I have it in front of me. So,
Okay.
so the first subpoena, you are requesting. Mr. Clerk, my subpoena, the documentation is not working all of a sudden. I do not know. If you could please pull up the subpoena. Oh, here it is. So in your actual subpoena, sir, you only asked for the physical presence of Trooper Alcock via video conference at 9 a.m. He is here, so he has fully.
In my original request to the court, how I went about requesting that subpoena?
That's not a discovery request, though, sir. That's just you telling us that's what you're going to request. That's correspondence to me. That's not a discovery request.
So how, I guess I don't understand the difference between getting this subpoena for the officer when I requested it that way versus getting the subpoena for the device when it was requested that way.
Unlike the human officer, however, a radar unit cannot speak, answer questions, or comply with any subpoena. Therefore, you do not subpoena the machine itself.
There are two types of subpoenas. There's a subpoena for a physical person, and Trooper Alcock here, there's a subpoena ducis tecum, which is a discovery request subpoena. That is a discovery, a completely different one. But I'm now looking over what you have requested. Mr. Clerk, can you please provide that to me? So you physically requested the devices. So you wanted him to hand over his speed measuring device?
No, I wanted the proof that I wanted the documentation of my speed. So it's my understanding, and forgive me if I'm wrong, but it is the state's requirement of proof to prove that I violated this law. Now, he said at the scene that he clocked me at 91 miles an hour. He wrote the ticket for 92 miles an hour. There's no proof other than him just saying, yeah, this is what I saw. When he pulled me over, I had never passed him. I was doing 68 miles an hour when he pulled me over.
All right,
There's no way. I wasn't even behind him. He was driving illegally in the left lane.
All right, sir. So first of all, 91 versus 92 is a moot point. You would get the same. But I'm just telling you, in his police report, it doesn't state anywhere that he said you were going 91. He has 92 and a posted 70. That's all he has. So I don't know if the recollection is different. I don't know if he said 91, but he meant 92. It's a moot point. It really doesn't matter. What exists is a police report. It says you're going 92 and a 70. This is valid. It's a public record. It's a business record from the Washington State Patrol that is a printout, essentially, of the speed that you were going. So did you get a copy of this police report?
No, I have not. I wasn't furnished anything that I was asked for other than the subpoena for the officer.
Okay. Well, it's not the court's responsibility to provide you with any of that information, sir. You wrote general correspondence of what you wanted to do. You got the subpoena out to get Trooper Alcock here. But other than that, we did not need to present you anything else. You needed to write your own legal documentation to request that.
Okay, well, and I apologize I didn't, but so I asked him, does he have proof? And the answer is no, right?
The proof is he answered that he observed you personally, personal observation. He wrote a police report. And I do have certification pursuant to IRLJ 6.6, which is a public record that you can find on the Washington State Patrol website that says that the specific radar that he used was calibrated, reliable, and accurate within the last 2 years.
Fair enough, but I still don't understand how he can, where is it showing my vehicle doing that speed? You know what I mean? Like there's
used a radar that has been certified by the state.
Okay,
and he's saying that he saw you, sir. It's your word versus his.
He said in his ticket that he saw a black truck going 91 miles an hour. I was driving a blue truck. He's claiming he saw me while he was a mile ahead of me He's claiming he saw a black truck in his rear view mirror and has no proof of my blue truck doing 91 miles an hour other than he says that it was. And so this truck, by the way, is not actually mine. It went back to the dealership. So I can't, all I'd be able to do is show you the proof of the color of the truck doesn't match his ticket.
All right. Is your truck blue?
Yes.
Okay. I have right here that,
This is black.
let's see. Okay. A black is yours, a Ford F-150 pickup.
It was a Ford F-150, yes.
Does it have the vehicle license plate number of 331?
He used that after he pulled me over. I mean, how would he be able to see that to pull me? This is my point, right? There's many Ford F-150s. All could be blue or black. He's saying that from behind, he clocked a black Ford F-150 doing 91 miles an hour. I was in the left lane doing 68 miles an hour in a blue truck.
So you were going below the speed limit, the safe speed limit.
I was. And that's in the record. I said that to him at on the scene. That's another reason I asked for the subpoena of the body cam footage, because I specifically asked him why he was pulling me over when I was doing 68 miles an hour. And he said he clocked me at 91 behind him. And I said, I don't believe that I was ever doing 91. And my other question to this would be, what if I was doing 89?
Here is the problem. The posted limit was 70. Whether you traveled 89, 91, or 92, you were still clearly speeding anyway, you complete idiot.
We're not doing subjective questions, sir. I have a full docket today. We're here to get to the point. We're not doing
my point is that I do not believe I was doing 91 or 92 miles an hour. The truck he claims he saw doing 91 or 92 miles an hour does not match the truck I was driving. Yeah, the license plate matches, I'm sure.
All right, sir. Thank you.
But there's no proof. And that's my point. There's no real proof that this was me doing.
Thank you, sir. I understood. Trooper Alcock, can you please speak to the difference in color of the car?
Yeah, apologies, Your Honor. So it was a dark blue Ford F-150 Lightning. When I initially observed the defendant weaving in and out of traffic behind me, I activated my rear radar.
I object to that, Your Honor. I was not weaving.
What is your basis for objection?
Because he's asserting I was weaving in and out of traffic.
He has personal knowledge.
I object to that because I was following the law by staying right, accepting to pass.
Overruled. Go ahead, Trooper Alcock.
So when I observed him weaving in and out of traffic behind me, that's when I initially exceeding the speed limit. That's when I activated my rear radar, which is in the central lane, and obtained the speed rating of 92 miles an hour. Like I said, it was a dark blue Ford F-150 Lightning with very distinct grille style, which is how I knew it was his truck and observed him as he approached me in the center lane. Then he slowed down, and I moved to the center lane, and we played this kind of game where he refused to pass me. So that's why he's saying 68 miles an hour. So I had to move over to the right lane for him to eventually move by me, so I was able to physically pull him over.
Okay. And Trooper Alcock, were you able to view his license plate prior to pulling him over?
Yeah, it was a temporary tag since it was a new vehicle that was posted in the rear windshield of the truck.
Okay, thank you.
So I'm sorry if if it was posted in the rear of my truck and you saw it before you pulled me over and you pulled me over from the front. How did you see it in my rear window? You were in front of me the whole time. How did you see my license plate in my rear window that you just said you saw in my rear window?
To clarify, it was because after I moved over and you passed by me and I pulled in behind you to pull you over and initiate a traffic stop, at that time I was behind you. Then I turned my lights on, initiated a traffic stop, and called out my traffic stop to the dispatch as I normally would, including the temporary license plate on your truck.
Thank you. Anything additional?
Well, again, it appears that obviously the police get to just change their story and say whatever, right? No real proof here. His documents do not match the truck I was driving. He pulled me over. He just himself said that he answered your question saying that he saw my license plate before he pulled me over. behind me and behind him. There's no proof, Your Honor, that I was doing 91 miles an hour or 92 miles an hour. There's no proof because I wasn't. I think he saw me driving as I should, which is to keep right except to pass. And that's Washington state law. It's posted everywhere. It says all vehicles are required to stay right instead to pass, except to pass. He was cruising in the left lane with a line of traffic, claiming I was weaving in and out. And there's no proof. And I think that, this is just why another example of why you can't trust the police, because he's just constantly changing his story to match his illegal ticket and his illegal actions.
You obviously missed the explanation, because the officer said he reduced his speed specifically to make you pass, allowing him to stop you. Instead, you slowed down beside him.
His illegal driving.
Regardless of whether we're in a physical courtroom or not, we show respect to all individuals, especially law enforcement. I mean, they do a great job doing what they do. I understand your frustration, sir, but he appeared here on your behalf so that you could have the benefit of the doubt to question him. And, I appreciate his time that was spent here. So I'm sorry that you were frustrated, but we show respect to any individual subpoena, regardless of what their occupation is. Based on that information, I do find that there is sufficient information to find that you committed this. I will mitigate it down. I do find that there is enough personal observation, as testified by Trooper Alcock, that he did see your vehicle. He specifically was able to pinpoint your vehicle. He did address the difference in color. He said that it looked black due to the fact that it was a very dark blue. I do find that that is an understandable difference. I do find that he was able to identify your license plate prior to actually pulling you over. So that is different than what you said. He was able to see you weaving behind him, but then you pulled in front of him, which gave him sufficient time to be able to specifically identify your vehicle as the one that he saw behind him. I do understand that you said the 68 miles per hour. Trooper Alcock did testify that that is the speed that you went to after he was able to clock you at 92. I do find that 91 miles an hour, as what you believe he stated when he pulled you over, is a moot point. 91 to 92, it could have been a misstatement. I don't see anything in the police report stating anything that he said 91, but even if we do believe your statement, that difference is minuscule and has no merit on this matter. In addition, I do believe that this speed measuring device was sufficiently calibrated and certified pursuant to IRLJ 6.6. I did look up the speed measuring device on the Washington State Patrol website, and as such, I do find that it has a proper certification, which is accessible to all public if they so happen to look. Based on that information, I will once again go ahead, find this committed, mitigated. I will go ahead and drop down your amount, though, to $150. I saw your hand raised. If you would like to make any additional statements at this point, feel free, sir.
No, I'm gonna refrain.
All right, sir, that is your choice. You have 60 days to make this payment or pay and or enter a payment plan. You have the right to appeal this ticket if you would like to appeal this ticket.
I will appeal.
All right, everyone, that brings today's video to a close. As mentioned, the first defendant may return once or perhaps twice, while people resembling our third defendant appear in court practically every day. If you enjoyed this video, press the like button. If you did not, press dislike. Either way, leave your thoughts in the comments and subscribe with notifications enabled so you never miss any content from this channel.